Jai Bhim to all. We are live on YouTube now, and I welcome all of you in the ninth lecture of the Ambedkar Online Free Law School. And today our subject is what is intellectual property rights and its importance to Bahujan Samaj. So today we are having Rishi Raj, who is an advocate, and I'm just giving a brief introduction about him, and then we will start our class. So today we have with us Advocate Rishiraj Singh. Rishi studied law at National Law University, Delhi. After graduating in 2015, he worked in general corporate law in Chennai for a brief period. He has also taught and mentored students for the common law admission test, which is the entrance exam for NLUs. He studied for his LLM at the Indian Law Institute, Delhi, and specialized in intellectual property rights. He was also a member of the editorial board of the ILI Law Review, which is a peer review online law journal published by the Indian Law Institute. After finishing his LLM, he continued with research in copyright law, particularly in the area of information justice. He has been studying how social arrangements in the society on information and distribution and their effects on human advancement have lived up to constitutional guarantees. Upon finishing his research, he aims to publish the same in the form of a book, after which he is targeting to pursue a PhD on the theme, information, justice, and poverty. Furthermore, he is also closely working with Advocate Nitin Meshram on a campaign for equality in digital communication. These campaigns include working on issues like access to internet, net neutrality, and freedom of expressions on the internet. So I welcome Rishi Raj Singh, and this is our ninth lecture, and it's good to see you, some of the guys over there, and we are live on YouTube also. On behalf of Ambedkar School, I welcome Rishi Raj Singh. Now floor is yours. Thank you.
Thank you, Brother Sumit, for the generous introduction. I would also like to thank Ambedkar Online Free Law School for giving me the opportunity to share my thoughts on intellectual property with respect to the Bahujan culture. So today we are going to discuss about intellectual property or IP. To begin with, let's go into the meaning of IP before we discuss the importance of intellectual property for Bahujans. IP can be broadly divided into 7 categories. These categories are copyright, patent, trademark, design, layout designs of integrated circuits, undisclosed information, and geographical indications, also known as GI. Let us understand each of these with the help of examples. If I write a piece of literature, or if I create an audio-video recording, then I have the copyright in that work. What this means is that I have a bundle of rights with me. I, as the owner of the work, have the exclusive right to reproduce the work, to issue copies of the work, to perform the work in public, to make translation of the work, and to make adaptation of the work. Basically, only I have the right to commercially exploit the work, and other people are forbidden from using that work or making copies of the work without my express or implied consent. The idea behind patents, trademarks, designs, and other forms of intellectual property is more or less the same. Let us take one more example and understand intellectual property from the perspective of patents. Patents are granted for new inventions, which can be a product or a process capable of industrial application. Broadly, what we mean to say is that if I invent any product or a process, then only I have the right to make and use that invention or sell or import that invention for that purpose in India. Again, the underlying idea is the same. My intellectual creation should not be used or economically exploited or commercially exploited by other people without my express or implied consent. Let us take another example, one more example, and understand IP from the perspective of trademark. Trademark is a mark which is used to distinguish goods or services of one person from another. Apart from serving the above purpose, trademarks also communicate to the public information about the quality, usefulness, make, and origin of the goods and services. Therefore, over a period of time, trademarks create their own brand value, which may run into millions and sometimes billions of dollars. And since trademarks are intellectual property, that is IP, Therefore, no other person except for the owner of the trademark can use that trademark or associate themselves with that trademark without the prior informed consent of the owner or the author of the trademark. I'm assuming by now some of our listeners have a basic understanding of what is intellectual property and what role does it play in a society. All these forms of intellectual property are governed by respective legislations. For example, copyright is governed by the Copyright Act of 1957. Patents are governed by the Patents Act of 1970. Trademarks are governed by the Trademarks Act of 1999. Designs are governed by the Designs Act of 2000, and so on and so forth. But apart from these forms of intellectual property, there is a whole new body of IP. It is known as traditional knowledge. Traditional knowledge can be referred to as knowledge held by a community which is orally passed on from generation to generation. It includes traditional cultural expressions in the form of folk songs, music, art forms. It also includes traditional medicine, traditional recipes, traditional technologies, and knowledge on biodiversity, etc. Traditional knowledge has been broadly classified into the following groups. Number one, cultural knowledge. Two, artistic knowledge. Thirdly, medicinal knowledge. Fourthly, agricultural knowledge. And finally, biodiversity knowledge. There are some other forms of traditional knowledge as well, like sacred knowledge, but we are not going to go into that. And spiritual knowledge as well. At the international level, there is a huge deliberation as to what is the best way to ethically monetize this knowledge. There have been instances in the past where Indian traditional knowledge has been monetized by Western pharmaceutical companies and they have obtained patents on medicinal use of certain plants. For example, in 1995, United States Patents and Trademarks Office awarded patent on haldi, that is turmeric, to University of Mississippi Medical Center for its wound healing properties. As a result, only one specific institutions, that is this university and the institutions to which this university has assigned the patent, had the exclusive right to sell and distribute the turmeric medicine, the haldi medicine. The Indian Council for Scientific and Industrial Research filed an objection to the patent granted and claimed that haldi or turmeric has been used in almost all Indian houses since centuries, and the Indian people have been aware of its medicinal usage since many years. While it is common knowledge in India that haldi is an everyday ingredient for Indian people, it was a Herculean task for the CSIR to find documented information about the healing qualities of haldi. After extensive research, 32 references were located in different language texts which provided for the healing properties of turmeric, that is haldi. Thus, the patent was not granted, and India was able to protect its traditional knowledge from being unethically monetized. Another example can be of the neem plant. An American company and the Department of Agriculture in the US filed patent on neem in the European Patent Office. The patent was about controlling the fungi on plants through the use of neem oil. This patent was objected to by the New Delhi-based Research Foundation for Science, Technology and Ecology, also known as RFSTE, in cooperation with the International Federation of Organic Agricultural Movements, that is the IFOAM. Also, another person known as Magda Elworth, who is the former Green member of the European Union, was also a part of this entire exercise. It was submitted that the useful properties of neem tree have been known in India since time immemorial. The barks, seeds, flowers, leaves have been used to treat a variety of diseases ranging from leprosy to diabetes and various skin diseases as well. Neem twigs, as we already know, have been used as antiseptic toothbrushes since ancient times. To substantiate its claim, India relied on ancient Ayurvedic texts. Let us take a third example, though it's a different one. The United States Patents and Trademark Office granted a patent to Rice Tech, which is an American company, for a strain of basmati rice, which is an aromatic rice grown in India and Pakistan, and it has been cultivated by these people for hundreds of years. In this case, the American company took Indian basmati rice and crossed it, mixed it with American rice strains to improve the starch index, the aroma, and the grain dimensions. It was objected by India, but since the American company had produced a novel, that is a new strain of basmati rice, and since United States is a strong proponent of patent protection on plant varieties, therefore the patent remained with the American company. So by now, we must have realized how important is traditional knowledge, and even more so, how important it is that the traditional knowledge is documented by these communities. There are many scheduled castes and the scheduled tribes which have a huge reservoir of traditional knowledge. And in spite of that, they are living in poverty. One of the main reasons behind it is that these communities have not documented their traditional knowledge. And the reason why they were unable to document their traditional knowledge is because they were denied access to education for hundreds and thousands of years. As a consequence of this, many times this knowledge is appropriated by other people and also monetized. Consequently, these communities neither get the economic benefit, the commercial benefit of their traditional knowledge, nor do they get the credit for the same, which is a denial of their moral rights. This is in gross violation of Article 27.1 of the Universal Declaration of Human Rights. Article 27.1 of the Universal Declaration of Human Rights reads as follows. Everyone has the right freely to participate in the cultural life of the community, to enjoy the arts, and to share in scientific advancement and its benefits. This provision provides a legal basis for indigenous and local people to be entitled to benefits arising from the use of their traditional knowledge and resources. Denying them access to the benefits would be construed as an abuse of their human rights. Furthermore, Article 27.2 of the Universal Declaration of Human Rights provides that everyone has the right to the protection of the moral and material interests resulting from any scientific, literary, or artistic production of which he is the author. Indigenous and local people have moral, cultural, and material interests in their traditional knowledge, and they are also the authors of such knowledge. Thus, their interests should be protected by protecting their knowledge and its resultant products. In addition to the above, appropriating the traditional knowledge of other communities is also against Article 27.3 small b of the TRIPS agreement. TRIPS stands for Trade Related Aspects of Intellectual Property Rights, and TRIPS is an annexure to the World Trade Organization. This article provides that member states shall provide for the protection of plant varieties through an effective sui generis system, that is a unique system in itself. This means that plant varieties are not patentable subject matter, and thus no person or body should be granted a patent on any plant variety. However, such plant varieties can be protected through a sui generis, that is a unique model, a unique system, which means that a mechanism has to be devised to credit these plant varieties to indigenous and local communities. Another international instrument which expressly protects traditional knowledge is the Convention on Biological Diversity. Article 8J is the most relevant provision of this instrument. It provides that each contracting party shall, as far as possible and as appropriate, subject to its national legislation, respect, preserve, maintain the knowledge, innovations, and practices of indigenous and local communities embodying traditional lifestyles relevant to the conservation and sustainable use of biological diversity, and promote their wider application with the approval and involvement of the holders of this knowledge, innovations and practices, and encourage the equitable sharing of the benefits arising from the utilization of such knowledge, innovations, as well as practices. It is interesting to note that the Constitution of India also contains provisions which can be used to preserve and utilize the traditional knowledge of various communities in India. Article 29, Clause 1 states, any section of the citizens residing in the territory of India or any part thereof having a distinct language, script, or culture of its own shall have the right to conserve the same. It must be noted that Article 29 has been listed in Part 3 of the Constitution of India, which deals with the fundamental rights of Indian citizens. Therefore, respect for the culture of these indigenous communities is guaranteed as a fundamental right, is recognized as a fundamental right by the supreme law. Furthermore, Article 51AF states, it shall be the duty of every citizen of India to value and preserve the rich heritage of our composite culture. These constitutional provisions can be used to persuade the governments to enact a national legislation on traditional knowledge. In India, different body parts of various animals are widely used by tribal communities for a variety of domestic purposes. Dry shell of unio for scraping, hairs of bears and horse for making ropes and paintbrush, coral for musical instruments, horns of buffalo for making buttons and combs, teeth of elephants for making bangles, etc., are common practices among many of the tribes. Apart from products of daily use, there are also certain animals which are used in traditional medicine. For example, now this is going to be a long list. Fat derived from more than 15 animals, especially of the wild ones, seems to be very effective medicine in curing all sorts of pain, including rheumatic pain. Fat is also used externally as a remedy for pain, impotency, skin burn, and paralysis. Likewise, there are many others such as flesh, blood, shell, feather, bile, liver, intestine, egg, honey, leech, termites, flesh oil, musk, antler, ghee, yolk, spider net, fish scale, etc., which are used in medicines and are used even today. The largest number of derivatives of a single species of bird is the hen's egg, having 36 applications in curing a variety of diseases, followed by the bird peacock with 22 applications, mostly related to stomach complaints, body ache, smallpox, chickenpox, and whooping cough. Not only, just hold on. Not only medicines, but even industrial goods and processes have sprung out of traditional knowledge. Two prominent examples stand out in this respect. Making of soil soaps by the dhobi or the washerman community has been recognized as a traditional knowledge. For a long time, the washermen at the dhobi ghat used plain water to wash clothes. But eventually they realized that it is not sufficient to get clean clothes in such a simple way. Therefore, they discovered soil soap. This soil soap is known as chodu mati in Telugu language. The chodu mati is not an ordinary soil available all over. It is a specific soil which is a light brown in color and contains the chemical properties of detergent. This soil, on touching, produces a burning sensation and washes off dirt from the hands at once. Initially, the Dhobi community mixed this soil in water so that it dissolved completely. Later on, they improved upon this technique and also starting heating this water and then dipped the clothes in this mixture to wash off the dirt and also kill all the germs. This entire process proved to be a very efficient method and was of great social utility. Such a process needs not only the ability to search for a soft soil that contains detergent-like quality, but also a comparative and a comprehensive grasp of various kinds of soil and their qualities. In some parts of Telangana, Chodu Mati is used even to this day. Even today, in areas where we have huge Thobi ghats, there are dedicated areas where they have enacted permanent cloth boiling structures. Let's take one more example. Another example is that of the Chamar community or the leather worker community who perfected the art of making clothes, water bags, handles, armors, footwear from animal hides. It has been recorded that the leather making community has perfected the art of converting animal hide into a durable finished product. Professor Kancha Elia Shepherd has recorded that the Chamars have invented 23 instruments that they use to convert animal skin into leather. This entire process is a four-stage process, after which the skin is converted into leather. After that, a fifth stage is also introduced where they rub the leather with kurukaya fruit to give it a polished look. Here I would like to quote a brief paragraph from Professor Kancha Lai Shepherd's book. I'm quoting, the scientific role of salt in keeping the wet skin from rotting was discovered by the Madigas/Chamars several centuries ago, and it still remains the primary condition of tanning in the Madiga Chamar Vadas of the remotest villages where nothing is known about the modern tanning processes. The soiled skin is dipped into the powder mixture of the bark of the Tangedu plant. This process continues for about 15 days. The tanners taste the sourness of the water every day. With each passing day, the skin absorbs some of the chemical content in the Tangedu water and begins to stiffen into leather. The semi-leathered skin is then put into a tub of lime. Within another week, it transforms into leather. It is then washed clean in a stream or a pond. This four-stage process of salting, dipping in Tangedu water, soaking in lime, and washing is the normal way of treating skin to change it into leather. To obtain a more sophisticated kind of leather, one final step remains. The Mardigas use the dried and powdered fiber of a fruit called karukara, as mentioned before. This fiber is boiled in oil and on cooling, it is systematically applied to the piece of leather in order to give it a polished, smooth, and black look. An odor, rather odd, is generated during the process of leatherization. But it is equally true that any industrial process, whether modern or of the Madiga classical type, has a dual outcome in the form of a commodity for human benefit and the release of pollutants. Unquote. I would like to further quote from another book by George W. Briggs. This is on page 257, he mentions, another native process consists chiefly of liming. First, the hides are laid on the floor and roughly fleshed, smeared over with lime, folded out. Each hide is then tied at both ends and placed in a numb containing lime solution position by means of a large stone. After 3 days, the hides are removed, unfolded and rubbed with lime, after which they are replaced in the numb and left for 4 or 5 days. They are then taken out, rubbed, scraped, cleaned and washed with clean water. When the hair and flesh have been completely removed, the hides are fit for tanning. The hides, which are now white, are soaked in clean water, to which is added a handful of fermented bark dust paste and allowed to lie for 2 nights. The hides are then folded lengthwise and twisted until all the moisture is squeezed out of them. They are then unfolded, wet, and twisted in the reverse way. This process of wetting and squeezing takes the place of baiting. The hides are then treated with tanning materials as above described. After the tanning process has been completed, the leather is curried with salt, curds, and ghee. This completes the process. So this is basically a short version of how to convert animal hide into a finished product. Thus, if a company uses any of these techniques for making a product such as rope, musical instrument, medicine, soaps, or leather products, then these communities should not only get economic benefits under a benefit sharing model, but also get their due credit as creators and preservers of such rich knowledge. Communities should be educated about the huge potential of traditional knowledge in modern age. They should be encouraged to document their traditional knowledge and get it registered with the Traditional Knowledge Digital Library, which is a e-library acting as a repository for all the traditional knowledge and traditional cultural expressions found in India. This will help in bringing the contribution of these communities in the mainstream society and also make it easier for them to exercise their right of attribution as well as share in the proceeds from the commercial or economic exploitation of these techniques. There are other various examples. For example, the shepherd community was the first community who had conceptualized and made wool into a blanket which would protect people of these communities from cold and dry winters. There are other recipes such as the kallu wine, which is a mild liquor, and you don't really get drunk; you get a little, tipsy, which is used by communities in Andhra Pradesh and Telugu in various celebrations. There is also the Feni wine, which is found in Goa. So there are numerous examples where traditional knowledge has existed and still exists even to this day. Now, let us come to trademarks. The idea of trademarks is not new. It is widely accepted that the earliest known form of branding or making of goods is that of animals. This was done by putting a mark on the cattle with hot iron by the farmer. This practice is also depicted in early Stone Age cave paintings and wall paintings in ancient Egypt. Another form of marking was where a slight part of the ear of the cattle was cut to differentiate it from others' cattle. This was known as the ear cut branding method and was prevalent in Madagascar. Some of the early evidences of semi-modern trademarking methods were found in the form of engraved symbols and signatures by craftsmen on pottery, jars, bricks, artistic creations, and tools. Even our own Indus Valley civilization shows practices which directly resemble to modern day trademark practices because it is a unanimous consensus of the international community that Indus Valley civilization had trade ties with the Mesopotamia and the Egyptian civilization. And how do we come to this conclusion? That is because certain seals which were found in Indus Valley civilization were also found in the Mesopotamian civilizations as well as the Egyptian civilization. Now, what function does that seal, fulfill? That seal fulfills the function of communicating to the people of Mesopotamia as to what is the origin of the good, who is the producer of the good, from where the goods have come. Therefore, these practices are very much in tune with the modern day trademark practices. What is important, another thing which is important to realize is that brands have a personality of their own. Before a person even picks up the product or chooses a service, they already have an opinion about them because of the trademark attached to these goods and services. As already mentioned, trademark not only fulfills the function of differentiating goods from one manufacturer from another manufacturer, but they also fulfill the function of communicating to the prospective consumer about the quality and durability of the goods and services. Some of the most valuable brands today are Amazon, valued at 220 billion, Google, which is valued at 160 billion, Apple, which is valued at 140 billion, Microsoft, valued at 117 billions, Facebook, valued at 79 billions, Walmart at 77 billion. Most of the well-known international brands today were once only local brands. Some of them were not even brands to begin with. For example, Google was started as a university project by Larry Page and Sergey Brin when they were both PhD students at Stanford University in California. Therefore, in my opinion, Bahujans who have an entrepreneurial mindset should not only use their creativity for running a retail shop or earning some sort of a rental income, but they should also create brands and register them under the Trademark Act. Another important aspect of trademark is that as more and more people start showing loyalty to your brand and your brand becomes increasingly popular, there might come a time where your brand may transcend national boundary. In such a case, your brand will become well known in other jurisdictions as well. In such a case, you need to protect your trademark on an international scale. For this purpose, we have the Madrid system for the international registration of trademarks in place that protects your trademark in more than 80 countries. The benefit of the Madrid system is that instead of filing a separate national application in each country of interest in several different languages in accordance with different national or regional procedural rules and regulations and paying several different and often higher amounts of fee, an international registration may be obtained by simply filing one application with the International Bureau through the office of the home country, in which one language, it can be either English or French or Spanish, and you can pay one set of fee. Similar advantages exist for maintaining and renewing a registration. Likewise, if the international registration is assigned to a third party or is otherwise changed, such a change in name or address, this may be recorded with effect for all designated contracting parties by means of a single procedural step. An interesting thing about trademarks is that in contemporary age, you do not have to stick to a traditional form of trademark, such as words, picture, or a 3D object. Today, we have the concept of non-conventional trademarks, such as color marks, sound marks, and smell marks. Sound marks can be understood with the help of the ICICI Bank jingle, and another instance of a sound mark is the Yahoo Yodel. And also when we boot our computers, when we start our laptops, if we have an Intel processor, we have a chiming of the Intel in a signature way, the Intel chimes. And all these all these sound marks are registered trademarks of all these brands. We even come to smell marks. In the United States, freshly cut grass, the smell of freshly cut grass was recognized, protected, granted as a trademark for a company which used to sell tennis balls. In another example, the vanilla scent for office supplies was recognized, granted, and protected as a trademark. Both these incidences are from the United States of America. Now we come to licensing and selling. As mentioned earlier, trademark have a personality of their own. Once your trademark gets popular and builds a loyal customer base, You can also license your trademark to other businesses who might be selling products or services which are related to your product or services. Furthermore, a trademark is classified as an asset for the business. Therefore, you can also sell your trademark for a certain amount of money, which obviously will depend on the value of your trademark then. Now let us come to the relationship of domain names and trademarks. Domain names are not governed by trademark law. Okay, first of all, let me just briefly introduce what domain names are. When we open a website, we type www.google.com in the URL bar. This www.google.com is the domain name of Google company. A trademark is different from a domain name. A trademark is a statutory right bestowed by law upon the owner to exploit or use a mark to carry out its business. Domain names do not have backing of the law. They are words or combination of words registered in the domain name system. Another major reason as to why domain names are not protected under trademark law is because domain names cannot be represented in graphical form or in a specialized font. When you type the address of a website in the URL bar, you simply type the name of the company. That's what happens in most cases. There is no freedom as to the type of font that you want to choose if you want to visit a particular website. This font is the same for all websites across the board. Thus, domain names are outside the scope of trademarks. However, there is one similarity. Just the way there can be no two domain names with the same name, even trademark cannot exist on the same ground. Similarly, in the domain names can be considered a ground for seeking infringement. That is, the customer with ordinary prudence being deceived by the similarity of names. Domain names are governed by Internet Corporation for Assigned Names and Numbers, ICANN. It is also known as ICANN, which is a non-profit organization that oversees the assignment of both intellectual property addresses and domain names. Now, let's come to the problems with domain names. Number one, cyber squatting. Cyber squatting means sitting over a domain name on the internet. A cyber squatter is someone who has speculatively registered or has acquired the domain name primarily for the purpose of selling, renting, or otherwise transferring the domain name registration to the complainant, who is the genuine owner of the trademark or service mark, or to a competitor of that complainant for a valuable consideration. Cyber squatters are also referred to as brand jackers or name jackers. One of the consequential features of domain names is that there can be no two domain names. Some large corporations today are keeping bounty hunters or cyber paralegal on a full-time 40-hour per week basis just to browse through the internet in order to find misuse of company names, trademarks, copyrights, and other intellectual properties on the internet. There are also many private corporations such as NetNames and Thomson & Thompson, which specializes in searching important trademark use on websites. Secondly, typo squatting. Typo squatting is a corollary to cyber squatting, where many domain name variants of famous trademarks are registered. This is because that there is a wide section of the consumer who would probably mistype a domain name. Typo squatters register one or more domain names that are misspelled words of famous trademarks. For example, a cyber squatter may register a domain name with the name Reebok, Reebok, which is a misspelled variant of a famous trademark called Reebok. Typo squatting misdirects the traffic to pages or products which may not have the same source of origin. They also commercially gain from it by providing space for advertisements. The intent behind typo squatting is no different from that of cyber squatting. Number 3, domain name parking. Domain name parking is when a person registers a domain name and then invites investors and buyers via internet advertisement to fill them with advertisements as opposed to constructing functional websites. This can be better understood by an illustration where a user who is interested in booking a Maruti car online visits such website. There is a likelihood of such user to type down or visit maruticars.com, believing it to be the legitimate site of Maruti Automobiles. When the web page opens, the user does not come across the official website of Maruti. Instead, he sees a list of links to other websites and web pages related to Maruti cars, including the names or products of the competitors of Maruti Automobiles. The parked domain, that is www.maruticars.com, presents consumer with the way or route, but the end product results in a failure as he was intending to go to the legitimate site of Maruti Automobiles. Number 4, gripe websites. These are domain names that are registered only for the purpose to go against the existing trademarks. These domain names act as a symbol of protest or parody against established brands. Generally, these domain names are registered by suffixing words like sucks, bad, I hate, etc. with the name of the original website representing the trademark. For example, I hate iPhone.com or applesucks.com can be the gripe website for the genuine website www.apple.com. Fifthly, we have the concept of reverse domain name hijacking. Reverse domain name hijacking, also known as reverse cyber squatting, occurs when a rightful trademark owner attempts to secure a domain name by making cyber squatting claim against a domain name's cyber squatter owner. This often intimidates domain name owners into transferring ownership of their domain names to trademark owners to avoid legal action, particularly when the domain names belong to smaller organizations or individuals. Reverse domain name hijacking is most commonly enacted by larger corporations and famous individuals in defense of their rightful trademark or to prevent libel or slander. Reverse domain name hijacking is a legal remedy to counter the practice of domain squatting, wherein individuals hold many registered domain names containing famous third-party trademarks with the intent of profiting by selling the domain names back to trademark owners. Our purpose of making you familiar with these concepts of cyber squatting and typo squatting and gripe websites is because when you are going to build your brand, you simultaneously have to keep in mind that you also buy the relevant domain name for your brand. If possible, you should also buy the gripe domain names of your brand so that a third party who may have something against you, maybe he doesn't like your brand, should not open a gripe website, therefore attacking the goodwill of your brand. So while investing in products and services, while investing in your trademark and your brand, you should also consider, sincerely consider investing into buying a domain name for your brand. With this, we come to a very important segment of our discussion, that is username squatting. Username squatting or impersonation refers to the improper use of username accounts on social media platforms to masquerade as another. Name squatting typically involves the registration of a particular username or account handle with a bad faith intent. For example, some squatters intend to sell to the domain or handle at an inflated price to trademark owner of that name. This typically involves registration by users who have no intention of using the account in a legitimate manner. For example, if I register on Twitter with the Twitter handle @the Shudra and therefore deprive Mr. Sumit Chauhan the legitimate claim of using that Twitter handle, then I am engaging in username squatting. It must be remembered that just like domain names, username squatting is also different from trademarks and trademark infringement. Social media platforms often pointedly make this distinction as well. For example, Twitter policies note, and I quote, if an account has had no updates, no profile image, and there is no intent to mislead, it typically means there is no name squatting or impersonation, unquote. Twitter indicates that it will not release inactive or squatted usernames unless there is a valid trademark infringement claim. However, what shall happen in cases of username squatting with respect to names of persons or associations? Twitter and Instagram and also Facebook in some cases have a declared policy that username squatting they will not look into unless you prove that you also have a registered trademark with that name, and only then they will listen to your application, only then will they heed to your prayer. But as already mentioned, in cases of username squatting with respect to individual people or associations, this is not the case. For example, if a person squats on the username which is likely to be used by a genuine individual user, then what is the policy adopted by Twitter, Instagram, Facebook is still unknown. Sadly, this vacuum is filled by back channel connections and nepotism. It is completely left to the whims and fancies of the social media website as to whom they want to allot the already squatted username. From my personal example, I can also tell, since I've been working with Advocate Nitin Meshram for a while, he shared it with me that he uses the Twitter handle @Nitin Meshram _. Now there is another Twitter handle called @Nitin Meshram, but this Twitter handle has not been in use since about a decade. This username has been in existence since 2009, 2010, but there have been no substantial amount of tweets, and it is not a very engaging account. And Twitter has a policy that if for 6 months your account is lying dormant, then they will take action against that account. This is extremely troublesome because after several decades and in contemporary times, the scheduled castes and the scheduled tribes have broken into the middle class, and now they are using social media to get their point across. But in a lot of cases, the usernames of Bahujan activists and organizations have been spotted. There is a likelihood that these acts of squatting have been done by the dominant caste people to keep the subordinated castes in check or to make them toe the line. One more example can be in the form of associations led by these communities. Say, for example, there is the SC/ST Association of Railway Employees. And in the backdrop of the rapid privatization of the railways, maybe this association wants to put a point across, and therefore they want to use Twitter as a medium to really get their point across through a wide circulation. If the Twitter handle SC/ST Association of Railway Employees is already squatted by another person, this deprives the genuine users of such a username from using this username to get their point across. Now, this association is not a company, therefore, SC/ST association is not a trademark, it's just an association of various employees. There can be a SC/ST association of engineers, lawyers, doctors, various things. But since it's not a trademark, therefore Twitter is not going to take action against the squatter of such a username. And therefore, these communities end up becoming victims in a way because somebody else got there first by virtue of their privilege. Moving further, It should also be noted that intellectual property rights create a monopoly over certain rights and practices. Therefore, these rights have to have an expiry date and they cannot continue for perpetuity. Therefore, there is the concept of time limit of protection. For example, copyright related rights continue for a lifetime of the owner plus 60 years, as mentioned in section 22 of the Act. Patent rights continue for a period of 20 years. Trademark related rights continue for a period of 10 years. After the expiry of 10 years, trademarks can be renewed for a further period of 10 years by paying a certain amount of fee. It should be noted that with respect to copyright and patents, there is no concept of renewal. The concept of renewal is only with relation to trademarks. With regards to copyright, the idea expression dichotomy must also be kept in mind. This means that copyrights are only granted for expressions of ideas and not for ideas themselves. We can understand this with the help of an example. If someone wants to make a movie on the theme of provincialism, showing a couple who wants to marry and the two people involved in this relationship are from different Indian states. I believe there was a movie on the same theme called Two States where actress Alia Bhatt and actor Arjun Kapoor were there. However, the idea expression dichotomy states that only the expression of the theme of provincialism, that is the script of the movie, the screenplay, the scenes, only these parts are subject matter of copyright. The idea itself is not copyrightable. This means that in future, anybody else can also make a movie on the same theme of provincialism, showing a couple from different Indian states where the people who are in the relationship are two people from two different states. And this person can also make a movie on the same theme, but the expression must be different. That is, the screenplay, the script, the scenes, etc., must not be the same. However, with respect to patents, we can get the idea who are protected under the Patent Act. As already mentioned, patents are granted for inventions which can be products or process capable of industrial application. Thus, if a person has devised a method or manufactured a product, then no other person can copy that idea and make a similar product. An interesting thing over here to note is that computer programs, algorithms are today protected under the Copyright Act because computer programs are nothing but a long list of codes in a certain sequence. And since all this is protected is in the literature form, therefore it's protected as a literary work under the Copyright Act. But in contemporary times, there has been a huge push and a demand for protecting softwares under the Patent Act. Now, there are two sides, two various camps. One camp basically says that you should protect softwares only under copyright because copyright protects the expression and not the idea itself. Whereas more proprietarian oriented people, more proprietarian oriented lobbies are arguing that software programs should be protected under patent because that will give them more monopoly. Because patent allows you to protect the idea, and whereas copyright allows you to only protect the expression of that idea. Uh, Next, we come to the topic of non-voluntary licensing. The provisions regarding compulsory licenses are given in TRIPS, that is the trade-related aspects of intellectual property rights, as I've already mentioned. And also all major intellectual property laws, that is copyright, patent, trademark act, have provisions of non-voluntary licensing. These are also known as statutory licensing or compulsory licensing. Copyright is the monopoly granted in exchange or as a quid pro quo for disclosure of work. Disclosure of various work enriches the society and keeps the march of mankind intact. Public interest is writ large through the idea of copyright, its protection, enforcement, and relinquishment. It is therefore an anathema to the conferment of copyright that the protected work is not made available for the general public consumption. Since dissemination of work is necessary, mechanism is provided to seek compulsory license in certain circumstances subject to just compensation being paid to the owner of the work. Section 31 enables a complaint to be filed before the Copyright Board with jurisdiction, which jurisdiction is now vested with the Intellectual Property Appellate Board when such refusal has resulted in the work being withheld from the public. Under Section 31 capital B of the Copyright Act, any person working for the benefit of disabled or differently abled persons can seek license from the board. It is significant that this license can be sought even with profit or business purpose. The board may, after hearing the owner of the work, grant license for the benefit of disabled persons. In the case of literary, scientific, or artistic work, if an edition is not available on or any copies are not sold for 6 months, then such work is not available at a reasonable price when compared to works of similar nature. Any person, any third person, public spirited person can seek license from the Copyright Board. Under the Patent Act, the provisions of compulsory licensing is mentioned in Chapter 16, and the conditions which need to be fulfilled are given in sections 84 to 92 of the said Act. Section 84 provides, at any time after the expiration of 3 years from the date of the grant of a patent, any person interested may make an application to the controller for grant of compulsory license on patent on any of the following grounds. A, that the reasonable requirements of the public with respect to the patented inventions have not been satisfied. B, that the patented invention is not available to the public at a reasonably afforded price, or C, that the patented invention is not worked in the territory of India. However, compulsory licenses may also be granted in cases in exceptional circumstances for exports, in case of national emergency, in case where a country which has insufficient or no manufacturing power in the pharmaceutical sector to address public health. We can understand this with the help of an example, a very contemporary and relevant example, that if today a pharmaceutical company finds the cure or a pill for the COVID-19 pandemic, then this particular company definitely has the right to get a patent on this particular drug. However, if this particular company turns sinister in some way and tries to reap a lot of benefits from these patents and it prices the drug very, very high, then this particular section 84 can be used to compel the patent holder of this drug and compulsorily license or use the form of statutory licensing to make this drug available to a large number of people at an affordable price. With this, we are moving towards the end of the discussion. One thing I would like to mention with respect to trademarks is that building the trademarks is a very high investment exercise, because it is not always possible that local trademarks over a period of time and gradually gain more and more loyalty, and therefore they gain more and more following and eventually they become big. In the modern era, companies invest huge amounts of money. They hire celebrities, they organize events, Coke Studio and the Devas, and there are many other examples. All these exercises are basically instances of companies trying to build their brand by investing huge amounts of money in them. Once your trademark has been protected, has become popular, it has become a well-known trademark, the story doesn't end there. because after that you also have to invest and spend money to protect that trademark. Because if a third party tomorrow starts infringing your trademark, then you definitely have to draw them into litigation. You have to file charges. There are civil remedies as well as criminal remedies under intellectual property rights. This must be remembered. So overall, trademark exercise might be an expensive exercise, but it is also a very rewarding exercise. Um, Towards the end, I would like to mention that we need to invest our time, and we need to create more and more literature, more artistic works, more brands. And I say this because the scheduled castes and the scheduled tribes are mostly landless communities. Landlessness in India has very much to do with a person's caste status. Since the SCs and the STs and certain subordinated castes within the OBCs, that is the other backward classes, not the dominant OBCs, since these communities are majorly landless communities, therefore I opine that these communities should firstly document their traditional knowledge and monetize their traditional knowledge. And secondly, they should invest in building brands, they should invest in building intellectual property, they should invest in building trademarks. Another thing that I would like to mention is that just how we have a feminist critique of education, feminist critique of law, feminist critique of Orientalism, feminist critique of science, war, globalization, etc. Similarly, we need to create literature on a subaltern critique of the various IPR regimes which are existing in the world. A subaltern critique of various concepts, various notions, various legislations is going to go a long way in bringing the concerns of these communities into the mainstream. For example, Professor Peter Drehos, who is a professor of intellectual property at the Australian National University, has he has been writing since the 1990s. He has a book called The Theory of Intellectual Property. He writes on the concept of informational justice. Now, what he means by informational justice is that the existing copyright regime, the way the copyright regime works, is that it gives too much power to the people who are creating the content, who are creating the data sets, who are creating the reports. Professor Peter Drehos argues that there is no such thing as an objective data. When I go out in the field, when I go and collect data, I record it in the form of a report. I always record it in a report format or in a tabular format. Or if I'm going out to measure distances, or if I'm going out to find out the contours of a geographical region, then I record it in the form of a map. So what Peter Drehos basically says is that since this data is not objective data, it is in the form of a report, therefore the author has a certain copyright into it. But when these authors and the owners of copyright in these works are given too much control as to who can access this literature, who can read this literature, at what price should the books be sold, which libraries should be able to, license, this work should be licensed to what all institutions and libraries. This, in the long run, is going to go against the idea of information justice. Information justice basically concerns itself with the ethical arrangements through which information basically circulates in a society. If information is not freely accessible and if it doesn't freely circulate, then in the long run, certain subaltern communities are definitely going to be victimized. I believe that is all that I wanted to share with you guys. Just to finally conclude it, I would just like to say that Bahujans should learn that they have a rich, productive culture to look up to. They should research in their own communities. They should research their own traditional knowledge, and most importantly, they should start documenting their traditional knowledge. After 1950, we have the right to be educated, to be literate, and therefore we should use this weapon of education to document our own culture and our own traditional knowledge. I say this because, and I would like to quote Dr. Suraj Yengde over here. Suraj Yengde says, Dr. Suraj Yengde once in a talk said that Dalits and Adivasis are experiencing their Harlem moment. Now, Harlem moment is, I mean, some of you must already know that relates to the city of Harlem, where the neo-Negro movement was started, and various black communities, African American communities, even with the help of Hispanic communities, they brought their own culture into the mainstream society. If during the neo-Negro movement, you would be walking in the city of Harlem, you can see on the road, somebody's playing the violin, somebody's playing the trumpet, somebody's making a very rudimentary form of jazz music. So all these things are now happening with the Dalits and Adivasis of India. Thirdly, we should realize that acquiring estate property is more difficult and a long drawn process. Therefore, the Bahujans should invest their resources into intellectual property such as trademarks, domain names, usernames, copyrights, patents, etc. And lastly, we should create our own literature, our own literary canon, and think about writing a subaltern critique to the IPR regime. That is all that I would like to share. Thank you for giving me the stage.
Yeah. Thanks a lot, Rishi, for a brilliant class. It was so nice to get in such, in-depth knowledge of the subject. You explained us very closely about the IPR law and its importance. It was really nice to hear you. Now it's time to take questions. I have some questions from YouTube also and some of mine too. Uh, so I'm just going to ask you questions. The first question is that can any invention be patented after publication or display in the public exhibition?
All right. So at the outset, I would like to mention that patents are only given for new or novel inventions. They have to introduce an inventive step into the invention, into the product, or into the process. If a certain idea is already existing in the public domain, and if it has already been documented somewhere, or if it is in the form of a traditional knowledge which we just talked about, then a patent will not be granted to that idea. For a patent to be granted, there has to be an inventive step, there has to be novelty, there has to be industrial application. Without these three things, the patent will not be granted.
Right. Another question I have. Uh, Mohit is asking on YouTube, does the patent office keep information of the invention secret? Like if you have invented something and you're, giving your information to the office, does they keep it secret? I just want to ask.
That's a very interesting question. While it might appear that my patented knowledge is a very state of the art knowledge, it is a very cutting edge knowledge, and therefore it should be protected. But it must also be mentioned that eventually every sort of knowledge has to enter the public domain. Now, with respect to the patent office, whether it gives out your secret, whether it spills your beans, what I would like to mention is that if there are two competing applications, and if one person has already gotten a patent or has already filed for a patent, and the other person files a similar patent, then the trademark office is definitely going to reject the second application. By the way, on a general principle, the trademark office, the patent office, they generally reject the first attempt of your application because they want you to really carve out how your invention is different, how your trademark is not deceptively similar, and other things. So the patent office does not hide the inventive step because it has to tell or convince the second applicant as to why your invention is similar to the first applicant, to the first applicant's invention. I would like to say that in case the company wants to protect certain secrets, then there is the concept of undisclosed information. Undisclosed information is also a form of intellectual property. For example, a very famous example, people have often said that the recipe for the aerated drink Coca-Cola is not given to anybody. Now, Coca-Cola company is hiding, or I wouldn't say hiding because it sounds really sneaky, but the Coca-Cola company is basically keeping this information within the boundaries of its own company by using the law of undisclosed information. So if you're an inventor, if you're inventing a new invention, a product or a process or a method, and if you don't want anybody to know about the technique, not even the patent office, not even the government, then you can use the law on undisclosed information to protect, to keep your techniques, your methods, your processes a secret with you. Yes.
We have Hani Babu with us. He is resident. Sir, you just unmute yourself. I'm giving you permission.
Yeah. Can I be heard?
Yes.
Can you? Yeah. Yeah. Thank you very much for the talk. I really enjoyed it. Just a couple of questions. I mean, minor ones. One thing which I have noticed is when it comes to brand name, quite often we see very casteist brand names. Like I don't know whether it's there in the north, but in the South India, like there are this Brahmins, sambar powder, and Brahmin is there. Even milk is there in Brahmin. So and which I think I mean there is a kind of freedom involved there, but at the same time I think this somehow is against an what do you call egalitarian principles, right? Because somehow it's reinforcing the caste hierarchy and all that. So do you think there should be this kind of thing should be allowed, or is it actually part of fair practice? Isn't there an unfairness involved when you are allowing brand names like this? This is one question. And the other thing is because what is interesting in this IPR is that on the one hand, there is this attempt to protect traditional knowledge and all that. But at the same time, we often see that there is a kind of predatory practices also, because one of the examples you mentioned, like the some company in the United States, you said had the fresh grass smell. That, and that's nobody's what do you call knowledge, right? I mean, that's not, you cannot. I mean, if a group says that we have a right over that, I think this kind of thing is like slightly problematic, right? And always it will be the marginalized and the Bahujan people who are then denied access to many things, because the law will always side with the mighty. So I find because although the idea is to protect the vulnerable people, but then it happens actually that the vulnerable people do not get access. So how does the IPR laws address this?
Thank you for the question, Professor Hani Babu. With respect to your first question, I would like to say that there are international instruments which do provide for a certain kind of check on scandalous or controversial forms of trademarks. In an ideal situation, obviously, trademarks which enforce caste stereotypes or trademarks which reinforce a form of caste supremacy definitely should not be given protection. But the owner of the trademark always can make this argument that it is nothing, it is just a trademark. Right. I mean, it is XYZ mobile phones. That's a trademark. I can protect it. One important thing over here is that Section 9 of the Trademark Act deals with inherent grounds of rejection, which basically says that one of the clauses says that a trademark cannot be descriptive. For example, I cannot sell Nagpur oranges under the brand name Nagpur oranges. That's descriptive, right? Or I cannot sell sweet ice cream or best yogurt ice cream under the brand name, best yogurt ice cream. your trademark cannot be descriptive in nature. So this could be an argument because I have seen, I also have people who I'm associated with in a friendly capacity, in a professional capacity, and there is that sense of, the catering service sometimes which they hire reinforces a form of caste supremacy, basically purity and pollution. It's a very old notion. But if it can be argued that these products and services are descriptive in nature, and again, you cannot really say it's descriptive in nature because there is no Brahmin, there is no Shudra, there are constitutional identities. SC, ST, OBC is a constitutionally created identity, and therefore, obviously, the general category becomes one. But I believe the argument that certain trademarks cannot be descriptive, this is one argument which can be used to sort of get these trademarks to be, taken out of the trademarks registry. And another way is that there are international instruments. The TRIPS agreement also, I believe, has some provisions which says that certain scandalous forms of trademarks should not be given protection. Having said that, I'd like to come to the second question which you asked, and you made a very sound observation because if a particular smell, if if it is going to be given protection as a trademark, then that's a very slippery slope. Because if tomorrow we are going to exclude other people from using certain tones of smell, then that creates a huge monopoly that opens the door for a huge number of things which can be monopolized. Another example is also of color marks. Color marks are also non-conventional marks. And what it basically says is that except for the 7 basic color tones, any other shade of these color tones can be protected as a trademark. So basically, a particular shade of the color yellow, of the color green, the entire color can be trademarked. This is extremely monopolizing in its nature. And again, there are camps on both sides which say that you should not give so much monopoly in the form of taste marks, not taste marks, in the form of smell marks and color marks, etc. And then there is the other side of the camp which basically says that if a person has invested so much money into building a brand, promoting the color, promoting the trademark. For example, in India, we had this detergent powder called Vanish Shakti or something like that, which was pink in color. Now that company, I believe, has a trademark for a particular shade of pink color. No other detergent can basically use that trademark, can basically use that pink color for selling their own detergent. They would be they would be slapped with a lawsuit. So yes, there are camps on both sides, but I believe in the longer run, the monopolizing tendency has to be curbed. That's why even countries like US are treading very slowly with respect to non-conventional trademarks. And ultimately, if we look, the point of intellectual property regime is to uh, is to uh, uh, is to churn information and to give new products and bring it into the public domain. So looking at it from that perspective, if the long-term perspective is to empower more people with more forms of goods and services and articles, therefore monopolizing should be curbed, and such forms of non-conventional trademarks should not be given as a free ride, as a free token is what I would like to say. Thank you.
Thank you, Rishi. We have some other questions from YouTube. Um, Mr. Walker, he has asked a question on YouTube that can you make patent of idea which is unique but yet to come in existence without any resources? Like if you have some idea and it yet to be come into existence, can you patent the idea?
Uh, can you just repeat the question? I couldn't understand the patent is new, but and it has not come into existence. Can you just repeat the question, please?
Walker have asked a question that can you make patent of any idea which is unique but yet to come in existence without any resources? Like it is not come into existence yet, but you have the idea. So can you patent your idea?
All right. Yes, I understood the question. So the Trademark Act does allow you to do that, but in a slightly different way. What you have to do is you have to explain your invention. You have to explain your process. Even if you don't have a final finished product, which you can take to the trademark, which you can take to the patent registrar's office and say, I want to get this technology patented. Even if you do not have that, you can still chalk out designs on a piece of paper. You can give a detailed description of the invention. You can give a detailed description of the construction of claims. In a patent registration, the most important thing is the construction of claims. The more things you can claim to be protected, the better your patent will be protected. If I make a gas pedal for differently abled people so that they can drive their car more easily, and if I have a lot of claims, but I only protect, if I have 10 claims, but I only protect 5 claims, then other people might make a gas pedal and capitalize on those 5 claims, which I had invented, but I did not claim it in my patent application. Another thing which I want to mention over here is that there are many instances where inventors and scientists have registered their patent with the patent office, and over a period of time, as they improve upon their invention, they keep on adding claims. They keep on adding the technology, the invention into their original patented process or patented product. So yes, even if you don't have a finished product, even if you have a semi-finished product, and even if your idea is on a piece of paper, you can still get patent protection on that. The law permits it.
Great, thanks for the answer. Uh, we have another question from Dr. Arun Kumar Moria from YouTube. Um, he has asked that what are the hurdles you see in the protecting traditional knowledge, which is mostly associated with Bahujans, and suggest some ways to overcome such issues.
All right. Thank you for the question. It's a very important question. One of the biggest hurdles of protecting traditional knowledge is the lack of a uniform system, the lack of a legislation. Because the TRIPS agreement has made it open for the member states, the countries, to enact a national legislation on their own. The TRIPS provides for minimum standards, and after that, it is the job of the national governments to enact a law. When I say enact a law, I mean create a sui generis system, a unique system of its own for the protection of traditional knowledge. So that national legislation has not been enacted. Moreover, another hindrance is that not a lot of research and development is going into monetizing these traditional knowledge. Traditional knowledge today in India is being protected only mostly in the form of the preservation concept, the preservation principle. Okay, here is a community, there are certain constitutional guarantees, we cannot, harm or we cannot violate their rights, so just preserve them. However, the aspect of monetization is not as much focused upon. A third reason is that there are various international instruments. One of them is the ILO, the International Labour Organization. It has a particular convention which only deals with the rights of indigenous people and specifically deals with traditional knowledge. But the problem is, so far, only a handful of countries, I think around 30, 34 countries have only ratified it. India has not ratified it, of course. One of the things is there. If member nations, member states ratify these important conventions, then it creates a obligation upon them to then, to then enact local legislations to protect such forms of knowledge. So I believe these are the hindrances. How to overcome these hindrances? Like I said, uh, it has only been a few decades since we have gotten the right to be informed, right to be educated, and therefore we need to create a lot of documentation. We need to understand that we do not have to solve the mainstream problems. For us, it is more important and more rewarding. I think we need to redefine accomplishment for the Dalits and Adivasis and other backward classes. Your accomplishment is not in solving the problem of the mainstream society. First, you need to solve your own problems. You need to come back to your own communities. Your success is not if you go become a top-notch corporate lawyer. When you're a corporate lawyer, you're not solving the problem of your community. You're solving somebody else's problem, which is also important, which also has relevance, and all knowledge is important. But I think we need to redefine accomplishment, redefine success with the context of the Bahujan people. And first, you need to learn how to come back to your own communities, how to solve your own problems. And one of the most important ways to do is to document your tradition, is to document your culture. And it is only when you have a solid literature on your own culture, which again loosely can be called as the Harlem movement for the Bahujans, then it becomes very easy to protect your traditional knowledge. And if the national governments are not protecting your traditional knowledge, then you can always use your traditional knowledge, document it, invent new products, invent new processes, and file an international application. Right. We have international application for patents as well. Just like how I mentioned, we have an international system, the Madrid system for the registration of trademark. We have an international system for the registration of patents as well. So we can sort of bypass this hindrance of having a local law. And since as a private person, as an individual, I can make an application to the international body for the registration of patents. Maybe we should start doing that now.
Thank you, Rishi. Now I would like to invite Hani Babu for a vote of thanks. Hani Babu sir, you can just unmute yourself.
Uh, yeah. Yeah. Am I audible?
Yes, sir.
Yeah. Okay. Yeah, I think this was a very important talk we had because intellectual property, I think, is going to be the property of the future because in like I don't think real estate and other things are going to be that important. So it's very important for us to be educated for the Dalit Bahujan Adivasi minority communities to be educated on this, to be aware about the rights. And I think this is a very good beginning that we have had. I hope we'll be able to have more talks on this subject in the future. And Rishiraj Singh being our own member, so he is always available to us. I thank him very much for this wonderful talk. And I also take this opportunity to thank all the participants who have joined both in this Zoom and as well as our YouTube viewers who have always been, very interactive and they have been always raising questions and all. But I'm I mean, the only issue that we have not been able to, have much talks in Hindi because there has always been a what you call demand from our audience on YouTube, especially to have more of bilingual or Hindi in our talk. So I think we'll keep that in mind. So thank you Rishiraj Singh, and thank you all of you for joining us. And we hope to see you again next week with another interesting topic. So thank you so much. Right. So you can close the call.
Thank you, Professor Hani Babu, and thanks a lot, Rishi. It was really, really enlightening to hear you, and your suggestion to go into invest in IPR is very, very important because that's the knowledge we are having. And as Hani Babu said, this is the real property we are looking for. So it is really nice, and I hope many of the people will be benefited by the information shared by you. We reached to more than 1,200 people on YouTube, and it was really a wonderful class. Thanks a lot for the lovely class. Thank you, participants, and hope to see you in next class on next Saturday in another topic. Thank you so much. We are going to end this class now. Rishi, thank you.
Thank you so much.